We will now call Senate Judiciary Committee to order. Thank you for joining us. We will go ahead and get started and open the hearing on Senate Bill 102. If we could have a bill brief from Mr. Reviser, Mr. Thompson, that would be appreciated. Thank you.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the Reviser's Office. Senate Bill 102 requires earlier notice of anticipated release from custody of a person who may be a sexually violent predator to the Attorney General and a multidisciplinary team, and specifies where such person will be detained during civil commitment proceedings. Section 1 amends KSA 59-29A02, the statute containing definitions for the Kansas Sexually Violent Predator Act. The definitions amended are agency with jurisdiction, and that clarifies that an agency releases a person confined or serving a sentence rather than a person serving a sentence or term of confinement. But the listed agencies remain only the Department of Corrections, the Kansas Department for Aging and Disability Services, and the Prisoner Review Board. Section 2 amends KSA 59-29A03, which currently provides that when a person may meet the criteria of a sexually violent predator, the agency with jurisdiction, that defined term we just discussed, must give written notice to the Attorney General and a multidisciplinary team 90 days prior to release or anticipated release of such person. The bill provides that on and after July 1st of 2022 and prior to July 1st of 2023, that notice will be given 90 days to 2 years prior to release or anticipated release. And then after July 1st of 2023, the notice will be given 2 years prior to release or anticipated release. Section 3 then amends KSA 59-29A05, the statute that addresses the process for a court to determine whether probable cause exists to believe that a person is a sexually violent predator. I noted that current law provides if a court makes a probable cause finding, the court directs the person to be taken into custody and detained in the county jail until such time as a determination is made that they are a sexually violent predator subject to commitment under the Act. The bill retains that law and creates an exception for a person who is subject to secure confinement at a correctional facility under the jurisdiction of the Secretary of Corrections, providing that when the person is no longer subject to that confinement, that the court will direct the sheriff of the county where the petition is filed to transport the person to the county jail and detain the person in the county jail until the determination is made that they are subject to commitment under the Act or not. Further, the bill adds a new subsection F to KSA 59-29A05 that applies when a person involved in a proceeding under the Sexually Violent Predator Act remains subject to secure confinement at a correctional facility. The subsection allows the court to secure the person's attendance at the proceedings by directing the sheriff of the county where the proceeding is held to take the person into the sheriff's physical custody and detain the person in the county jail for such time deemed reasonable to secure their attendance at the proceedings. Finally, there's a new subsection G that says nothing in these new amendments creates specific rights for the person alleged to be a sexually violent predator. And with that, I will stand for questions. Oh, I apologize. I will note that this was Senate Bill 416 last session. It did receive a hearing in this committee, but it did not receive any further action. And with that, I'll stand for questions.
Thank you, Mr. Thompson. Committee, do we have questions for the reviser? Senator Thompson.
Thank you, Madam Chair. Just one, Mr. Reviser. I'm assuming there are objective standards for deeming somebody a sexually violent predator under the statute. I'm looking at the statutes real quick, the 59-29A03.
Mr. Thompson, are you able to answer that?
Yes, Madam Chair, and I see you have a conferee on from the Attorney General's office who does this more than I do. I only know the statutory pieces, but yes, the Kansas Sexually Violent Predator Act, beginning in 59-29A01 and going for several statutes, has a number of procedures, criteria, findings that have to be made before you can civilly commit someone under that act. So yes, there are criteria, and I don't think they're in this bill as much, but they are in that act.
Okay. Thank you, Madam Chair.
Committee, any other questions? I have one. Did this come to committee from the Attorney General's office? Mr. Thompson?
Yes, thank you, Madam Chair. Jason Thompson again. Yes, this was requested in committee by the Attorney General's office, and I believe they're here to testify in favor.
Thank you. With no further questions for the reviser, then we will invite our first proponent, Conferee, Dorinda Mitchell, from the Office of the Attorney General, to testify, and she's appearing via WebEx, so please introduce yourself and welcome to committee. If you're speaking, we're not able to hear from you. If you could maybe unmute your mic and we'll see if that changes anything. Still not hearing Ms. Mitchell. So then we will come back in a few minutes after we hear from Greg Easter, our next proponent conferee from the Kansas Sheriff's Association, appearing via WebEx. If you'll please introduce yourself and welcome to committee.
Good morning, Chairwoman and Senators. My name is Jeff Easter with the Sedgwick County Sheriff's Office. It's all right, ma'am. And I'm here for the Kansas Sheriff's Association. And so what this bill would do right now, currently, individuals that are looking at this particular act, the Sexual Violent Predator Act, 90 days before the release, a DOC evaluation takes place, and then the Attorney General's review period takes place. And then they're placed in the county jail for sometimes as long as a couple years before a determination is made, before they're sent to treatment. And so the proposal, which we appreciate the Attorney General's office making this proposal, simply extends the period that DOC would notify the AG's office of this sexually violent predator that could fit the act, for the AG's office to start the process in court of filing the proper paperwork, those type of things. I really would take your attention to the second page of my testimony, my written testimony, which really depicts the amount of time while they're serving the sentence for their current charge. The evaluation and the court process is taking place while they're in prison instead of being released on their particular charge, and now looking at the Sexually Violent Predator Act while sitting in the county jail. And that's what we would like to see changed, so that while they're sitting in prison on the initial charge, they're going through this process. And I'll stand for any questions.
Thank you, Mr. Easter, and I apologize for the name there. It was written down wrong, so I will not make that mistake again, I hope. Thank you for your kind acceptance of the apology, and we'll get that right. Wanting to then turn back to Dorinda Mitchell from the Office of the Attorney General, if you are on WebEx and able to turn your mic on and introduce yourself, and welcome to committee. Ms. Mitchell, IT personnel here has said we can see you talking, but we can't hear you. And I think the microphone at your end needs to be unmuted. So if you could unmute on your computer, we could probably then hear you. If you want to give that a try, please. We're still not able to hear you, Ms. Mitchell. If you're able to unmute your mic, give it another try. We're not able to do anything to help with the microphone situation here in the committee meeting room. Give it one last try, and if we're not able to hear you, we will circle back at the conclusion of proponent conferee testimony and see if we can get you on the mic then. With that, I will ask, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then one last call for Dorinda Mitchell from the Office of the Attorney General on WebEx. If you want to try again to unmute your microphone at your end, at your computer, that would probably be the solution we're looking for. Thank you. We have someone in the committee meeting room trying to contact the conferee to see if we can have her testify, possibly on speakerphone at the mic at the podium. We'll give that a minute or two, but doesn't look like we're able to reach her, but we will come back before we close the hearing today to see if we can reach her and get testimony heard from her. Thank you. With that then, committee, we will open it up for questions of our conferee. Yes, Senator Gossage.
Thank you, Madam Chair. The question is for Mr. Easter. When I'm looking at the fiscal note on this, it's over $1 million, but yet we're talking about how it relieves the county prison or the county jails. Can you address that, or do we need to ask the revisor?
Mr. Easter, if you're able to answer.
Yeah, I have not been provided with the fiscal note. So I would not be able to answer those questions. I don't know if it's something to do with the program, because you're simply asking KDOC, who has to track this already and notify within 90 days, to notify 2 years before. So I don't know what that fiscal note would be about. I'm sorry, I can't answer that.
And if it's okay, Madam Chair, may I ask Mr. Thompson, the revisor? Because I do note that it says, it would be $229,000 would be for 2 contract clinical service report writers. $75,000 would be for an administrative FTE. $660,000 would be 8.00. I'm not sure what that means. Program treatment provider. But I'm not seeing any savings that this would be from the county jails.
Mr. Revisor, if that's information that you have, or Kansas Legislative Research Department, or it might be a question for someone else, but if either of you are able to answer.
Madam Chair, this is Jason Thompson with the Revisor's Office. I just will say that we do have a copy of the fiscal note, and it appears that it is generated entirely by the Department of Corrections. And I note that they also provided written neutral testimony from Mr. Randy Bowman. I don't see him on WebEx. I don't know if he's there in person. I doubt it. But we could direct those questions to the Department of Corrections. And I think in the testimony, they clarify that because of when they have to start this process and the difficulty of meeting the timeline, they generated a fiscal note because of that. The costs locally that Sheriff Easter was discussing would not be reflected in the fiscal note because those are not part of the state budget. So the director of the budget is not concerned with the cost savings locally, but those are the cost savings that Sheriff Easter was referring to. I believe they'd be at the local level rather than at the state level.
Thank you very much, Mr. Thompson. Thank you, Madam Chair.
Sure. And committee, I will note that Mr. Randall Bowman from the Kansas Department of Corrections is present in the committee meeting room and will be providing neutral conferee testimony to us today. Yes, Senator Pyle.
Thank you, Madam Chair. I don't know who can answer this question. It's along the same lines as the prior one. In the new section, subsection F, be page 6 of the bill, where it says that it'll allow the court to secure the person's attendance at the proceeding by directing the sheriff of the county, excuse me, where the proceeding will be held, to take the person into the sheriff's physical custody and detain the person in the county jail for such time deemed reasonable to secure the person's attendance. And I'm reading from the revisers. I'm curious about the costs there, since you're taking them from DOC and now transferring them to the sheriff's location for the proceeding. Who is absorbing those costs of transport and all of that? And I did read the fiscal note. I know there's some of that is, but when they're housing them at the local county jail, is the county jail reimbursed for that cost from DOC? Do we have an answer for that question?
Yes, Senator. So in most cases, I know here in Sedgwick County, if a person that's in KDOC custody is needed back in court in this particular county, we are responsible for transport and we are responsible for housing. There is not any reimbursements that's given to us because they're needed in court in this particular county.
I may, Madam Chair. So the costs, the burden will fall to the counties on all of these additional costs. I'm wondering if the fiscal note reflects the savings to DOC while they're being housed in the county. Anyone know?
I'd have to take a look specifically at where the fiscal note describes that. I wouldn't think that if it's a local issue that it would have been accounted for in the fiscal note.
Thank you.
Thank you. We do have information that our other proponent, Conferee, Dorinda Mitchell, from the Office of the Attorney General, has been able to call in on WebEx. So we will ask her to please identify herself and welcome to committee.
Thank you, Chair and members of the committee. My apologies for our earlier snafu. I'm not sure what happened. I have someone who's very computer literate right here with me, and we both were unable to figure out what the problem was. So I'm glad we are able to appear before you by phone. Again, thank you for the opportunity to offer this testimony in support of Senate Bill 102. Simply put, the bill requires the notice to the Attorney General from the agency with jurisdiction to be given earlier in the process while the sex offender is still in KDOC's custody. Our office has been working with the Kansas Sheriff's Association for many years on ways to reduce the burden that the process of commitment of sexual violent predator commitment places on our county jails. In answer to an earlier question about whether the fiscal note reflects the savings to the county, the current process is that the county has to bear all the expenses of transport, housing, and security under the Sexually Violent Predator Act. So that is currently a part of the existing statute. KDOC does not have to pay for transport, security, and those measures under the current operation of the bill, or the current operation of the law. The bill before you today is an attempt to address some of the concerns that the Sheriff's Association and the Attorney General's office have encountered. And we believe it would be good public policy to undergo the legal process of commitment during the time the individual is serving their sentences, and then be transported to jail from KDOC only if their sentence has expired before the SDP adjudication is final. Under current law, the agency with jurisdiction, usually KDOC, as Mr. Thompson pointed out, notifies the Attorney General when an individual in their custody may meet the criteria of a sexually violent predator. Currently, the statute provides that that is 90 days prior to their anticipated release. The Kansas Department of Corrections determines what individuals may meet the criteria using an internal process that includes programming and evaluation of the individual. After notice is received by the Attorney General's office, a prosecutor's review committee within the Attorney General's office reviews the notices and the evaluations performed by KDOC's multidisciplinary team and determines whether the individual meets the criteria of a sexually violent predator. The commitment process involves additional evaluation and judicial hearings, which can take many, many months. As you can imagine, there has to be an opportunity for the individual to present his arguments and to provide his expert testimony in response to what the state has offered. The individual is also entitled to demand a jury trial to determine whether the person is a sexually violent predator. Whether the person is a sexually violent predator must be proven by the state beyond a reasonable doubt. So it's a rather sophisticated and involved litigation process. The standards, in answer to another one of those questions, the standards are primarily contained within KSA 5929A02A, which defines who a sexually violent predator is, what that term sexually violent predator means. And it is a person who has been convicted or charged with a sexually violent offense and who suffers from a mental abnormality or personality disorder that makes the individual likely to engage in future acts of sexual violence and who has serious difficulty controlling their dangerous behavior. The current process envisions that all the litigation involving that question about whether the individual is a sexually violent predator is conducted while the person is held in the county jail rather than what we are proposing, and that is that the individual be held in the KDOC before their sentence expires. This places a significant cost on our counties under the current system. The Kansas Sheriff's Association has estimated this cost at more than $600,000 per year, based upon an estimated 20 persons being held in the county jail at any given time. And that is our rough average of the number of petitions that we have pending at any given time. Currently, we have 16 individuals on that are subject to petitions that we have filed and that are being held in county jails, but that will even change tomorrow when a new person is taken to the county jail, if all things go as planned. The Sexually Violent Predator Act does have in its provisions a fund that is held within the Attorney General's office to reimburse the counties for the cost of persons being held in county jails, awaiting this determination about whether they meet the criteria of a sexually violent predator. However, the appropriations made to that fund fall short of the actual costs that the sheriffs are having to and the counties are having to afford. For fiscal year 2022, the governor has recommended appropriating only $50,000 to that fund, that litigation fund that is held by the Attorney General's office. Counties' expenses submitted to our office for reimbursement will quickly deplete those funds. Once the fund is depleted, the only recourse the counties have then is to seek reimbursement through the special claims process against the, through the legislative process. And that brings us back to the bill before you today, Senate Bill 102. The bill would seek to reduce significantly that cost afforded now by counties and in particular by sheriff's departments, because the amount of time that the individual would spend in the county jail would be significantly reduced. Beginning July 1, 2002, DOC, under the proposed language, would notify the Attorney General's office of the anticipated release of someone who may meet the criteria of a sexually violent predator. This would allow the civil commitment process to begin sooner while the individual is still in the Department of Corrections custody. Ideally, this will allow some persons who are civilly committed to transition, if they are found to be a sexually violent predator, through the litigation process by a jury or by the court, to transition to be transported directly from KDOC to SPTP at the Kansas Department of Aging and Disability Services, which is currently at Larned. We understand that this will not entirely eliminate the role of the county sheriffs and the jails in that process. We are greatly dependent upon sheriffs and are grateful for their services in providing transport to these individuals, to the jails, to the counties, so that these individuals can make appearances in court during this litigation. In addition, judges may require individuals to appear in person for hearings other than what is contemplated under the Act, and almost certainly they will be allowed to appear at trial. However, we believe that this legislation, Senate Bill 102, is a good step for greater efficiency and cost savings, and allows the possibility of treatment closer to the time of the individual's release from KDSC. So ideally, the individuals subject to commitment will be treated sooner in the process than they might otherwise have been treated. Thanks for your attention to the matter, and I stand for questions.
Thank you, Ms. Mitchell. Appreciate your continued perseverance to appear in committee today and provide testimony. Appreciate that. I know it's not always easy with the technology. Committee, do we have any questions for any of our proponent conferees now that we've also heard from the Office of the Attorney General? All right, seeing and hearing none then, I will direct committee's attention to, we have opponent written testimony. I think it's being delivered. It's not yet probably in your committee folders, but an assistant is bringing that down. I will then ask, is there any opponent conferee in the committee meeting room or on WebEx? Seeing and hearing none then, we will move to our neutral conferee, and that would be Mr. Randall Bowman from the Kansas Department of Corrections. So please introduce yourself and welcome back to committee.
Thank you, Madam Chair. Randy Bowman, Kansas Department of Corrections, titles Executive Director of Public Affairs, and it's a privilege to be before you, Chairperson, and members of the committee today on this topic. The Attorney General's office did an outstanding job describing the process and the bill and the process, how it works today. I will add one part to that, and it really sets up this discussion, hopefully, on why we need your help for resources. But as I do that, I want to first be as clear as I can possibly communicate. We see changing this timeline makes sense. We are not opposed to that principle. We simply need your help on the resource side of it, and I'll try to help that make more sense as I speak with you here today and answer any questions. So for the process today, when it's a 90-day notice, The process of screening and assessment that was talked about and then doing actual treatment has to actually start for us about 15 to 18 months from the person's scheduled release. So today we have a set of resources dedicated to that purpose. So if you will, let's take that back up. So to go to 2 years, we need to back up to about 36 to 39 months before release. So we take that resource and push it back in time to 36 to 39 months. And yep, we can keep treating those folks, meet this timeline, notify the Attorney General at 2 years. Hopefully it's good evidence that then he can make good solid cases to the court, get those cases through the court system before the prison sentence expires and reduce the likelihood they have to be housed in county jail as they are today. Here's the challenge for us. We back that resource up in time to 36 to 39 months. Nearly, just at our 0 to 6 months of new admissions, 35% of our sex offenders on a 3-year average only serve 6 months. Another about 8% serves a year. So while we're back up with our resource serving the 36 to 39 month group, all these people are coming in the door who also need sex offender treatment, also need screened to see if they might be sexually violent predator candidates, but we no longer have that resource to treat those short-term ones. So that's where the 1.3 million figure that Senator Gossage talked about and the specifics of staff comes in. We need to add the treatment and the screening staff so we can treat basically 2 cohorts. Those that hit the 36 to 39 month trigger, working towards 2 years, and then all of those who are coming in the meantime with very short sentences, but still need that same screening and more often than not, that same treatment. We spent in 2020 about 1.8 million on treatment. Our ask is for about 1.3 and change. I don't remember that exact number, apologize. It doesn't double it is my point there, but it is a pretty substantial increase in workload. In 2020, our folks processed about 378 cases under the current methodology, of which we turned over 9 of those to the Attorney General's office for filing. So I think the jails see some stacking effect too. So if we turn over 9 in a year, because it does take a while, they've still got some from the prior year probably working their way through the system. So to recap, we have those folks coming in at short intervals that also need this, so we need to expand our treatment capacity to do this. Again, it makes sense to us. Do this legal proceeding while they're still in our facility instead of after the sentence is over. We just simply appreciate the legislature at large helping us with the resource part of it. And with that, Madam Chair, I'll stand for questions.
Thank you, Mr. Bowman. Appreciate that. Are there other neutral conferees in the committee meeting room or on WebEx? Hearing and seeing none then. Committee, do you have any questions for our conferee, Mr. Bowman? Seeing and hearing none then. Committee, I do want to bring to your attention that the written testimony from opponent conferee Jennifer Roth from the Kansas Association of Criminal Defense Lawyers and Legislative Committee co-chair has been handed out to you during our committee meeting. And if you've taken a chance to look at that, I do have a few questions probably for Ms. Mitchell that's raised in the opponent written testimony, just to make sure that we're covering everything that needs to be covered. There's been some constitutional questions raised about if there's no statutory right to appear at a hearing absent a court order, and if there's no statutory right whatsoever in the amount of time the person is detained in the county jail to secure the person's attendance at a proceeding. Do these rise to the level of constitutional problems, or would these not be a constitutional problem for the state?
Madam Chair, is that directed to me?
Yes, Ms. Mitchell, if you're able to answer, and please identify yourself for those listening online.
Okay, thank you, Madam Chair. This is Dorinda J. Mitchell, the Director of the Sexually Violent Predator Unit in the Attorney General's Office. That question about whether the amount of time that a person is held in jail has been litigated in the case of Ellison versus the matter of Ellison. And the Kansas Supreme Court has held that because the speedy trial provision is a statutory provision subject to the criminal statutes, and because the speedy trial provisions under the U.S. and state constitutions involve criminal cases, that per se does not apply. However, there are due process considerations that need to be met. So it is conceivable that a person can be held too long. This process will help alleviate those concerns because the individual will be held under their criminal sentence during part of this litigation. It will cut the amount of time that they're held in the jail rather than extend the amount of time that they are held in the jail. With regard to the other question about whether they have a right to appear, again, these are civil proceedings. There are statutory rights on when the individual can appear. That is when they are subject to trial. And the probable cause hearing, they have a right to be present. But ordinarily, there is no right to be present at a civil proceeding under the state or federal, under the U.S. Constitution. There is also case law on that issue. It's a decision that was not a reported decision, and it's a matter of Smith. In essence, there's a statutory right, and so those provisions are honored, and the individual does appear in court. And when the individual does appear, the Sheriff's Department is the entity obligated to make sure that that person appears in the courtroom at that given time.
Thank you so much for educating the committee and the public on that question, on that issue. Committee, any other questions for any of our conferees, actually? All right, seeing and hearing none then. I want to thank each of the conferees who appeared to testify today, both in person and on WebEx. We appreciate you taking the time to spend your morning here with us and give testimony on Senate Bill 102. With that, then, we will close the hearing on Senate Bill 102 and open the hearing on Senate Bill 204. If we could have Mr. Revisor, Mr. Thompson, give us a bill brief.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office again. Senate Bill 204 prohibits a court from requiring psychiatric or psychological examinations of an alleged victim of any crime. Section 1 would enact a new law to provide that in any prosecution for a crime, a court shall not require or order a victim of the crime to submit to or undergo either a psychiatric or psychological examination. And this new section will be part of our Kansas Criminal Code. I will note for the committee that last year you heard a similar bill as Senate Bill 355. The committee decided to amend the bill from dealing only with victims of specified offenses, mostly sex offenses, and instead made the prohibition on these exams for all victims of crime. And that bill then passed the Senate as amended, 39-0, went to the House and received a hearing in House Judiciary, but then the session ended and the bill died at that time. I stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the revisor? Seeing none, we will invite the proponent conferee, Mr. Todd Thompson from the Kansas County and District Attorney Association, Looks like he's appearing on WebEx. Please introduce yourself and welcome to committee.
Hi, committee. Can you hear me okay? I've had problems with my WebEx as well.
We can. Thank you for checking. Go ahead.
Okay. I will say I am the third Thompson in this meeting, and I believe I am not related to any of the other Thompsons. So I will acknowledge that. If you say Mr. Thompson, I might try to answer anyway. As Jason Thompson pointed out, this was passed all the way through the House, and
Could you go ahead and identify yourself, though, for those listening online? Thanks very much.
Oh, I'm sorry. I'm not only the Leavenworth County Attorney, I'm also past president and chairperson of the legislative branch for the Kansas County and District Attorneys Association. And I am testifying as for the Kansas County and District Attorneys Association, who asked to have this bill once again proposed. We do believe that the only reason that it did not get passed last year is due to the pandemic that occurred that the courts had stopped. Obviously, I'm not sure if anyone in this committee has ever been a victim of a crime or had a family member, but basically imagine when you go and have to testify or tell the law enforcement and you see that it gets charged, you are now required to do a psychiatric examination to show that you're not suffering some mental condition that transforms into a fantasy or a wishful biological urge. And that was language used in State v. Gregg that allowed for this types. This law is still on the books, and defense attorneys and judges are still granting them. In fact, we have one in my county that has been granted, and we have a young girl who will be facing testing at this point. I'm sure you can imagine the trauma that it would instill on any child or anyone really to have to undergo that just for coming forward. It's already such a difficult situation for anyone to come forward with a crime. Sexual assault's one of the worst crimes anyone could face. Many times it's from someone they love or they trust, a close friend, a relative, a family friend. And then they're not only, once they have to tell the law enforcement or a forensic investigator, and discuss it with the prosecutor, but the court is telling them that they have to now go to get this mental health evaluation. Our Supreme Court recognized that this type of motion can be seen as a fishing expedition and really should not require it except for extenuating circumstances. And what we're asking is that this just should not happen. There's no truth to it. It's a archaic law based on misogynistic views, and it's quite unnecessary. And it's unsupported by any valid evidential testing. As Kim Parker, our prosecutor coordinator and well-accomplished prosecutor, said last year when testifying, the veracity of a sexual assault victim should be subject to the same test of all victims. Solid investigations, prosecutors' careful review of the facts, thorough cross-examinations, and determination by the court and the jury of the credibility of the evidence. This should not be something that can be asked of them, much less for the sexual assault. And we do stand by the amendment that happened last year. And with that, I thank you for the time, and I stand for any questions.
Mr. Thompson, appreciate your testimony. Are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, committee, I'll direct your attention to your committee folder. It has proponent written conferee testimony from Sarah Rust Martin, the Kansas Coalition Against Sexual and Domestic Violence. And with that, then, we will open it up to committee questions. Yes, Senator Pyle.
Thank you, Madam Chairman. Mr. Thompson, can you tell me, I'm not an attorney, I'm not familiar with this. When the court orders this testing, who's required to pay for it?
Most likely the state, Your Honor, or not Your Honor, Senator Pyle.
All right, thank you.
Thank you. Any other questions, committee? All right, seeing and hearing none then. We do have neutral written testimony in your committee folder from Jessica Glendenning, the Kansas Association of Criminal Defense Lawyers. Do we have any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. Committee, I don't have any opponent conferee written testimony in the committee folder from anyone, or opponent conferees signed up to provide testimony, but I will ask, are there any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then I will thank you, Mr. Thompson, Mr. Todd Thompson, right? For appearing in front of committee today. Appreciate that and appreciate your time and the testimony you offered. With that, we will close the hearing on Senate Bill 204. Committee wanted to talk a little bit about bills that we will be working. We're looking at turnaround next Friday, so we have a couple of things to accomplish before then. One of them is we will be looking at the Kansas Emergency Management Act, so please be prepared next week, possibly Tuesday, Wednesday, Thursday, to be hearing a bill on that, and I would ask committee to be prepared to bring a lunch maybe and work through the lunch hour so we can get through the bill. It's going to be pretty big and comprehensive, and we want to make sure we have all the conferee testimony we need and all the robust debate and discussion that we need. So we'll be looking at that probably Tuesday, Wednesday, Thursday-ish of next week. So please be prepared. Also, a couple of bills that we will probably be working in the next, I guess this week and next week, would be Senate Bill 8, Senate Bill 104, Senate Bill 105, Senate Bill 106, Senate Bill 122, and possibly Senate Bill 204 that we heard today. And in fact, with the committee's permission, without objection, we'll go ahead and work Senate Bill 204 today that we just heard. If there is no objection from the committee, seeing and hearing none then, we'll turn to working Senate Bill 204 that we just heard regarding prohibiting a court from requiring psychiatric or psychological examinations of an alleged victim of any crime. If committee needs time to prepare some amendments, we can work it a different day, but I'm not seeing that there are any requests that we delay this for some amendments, so we'll go ahead and work Senate Bill 204 and open it up to any discussion or a motion. Yes, Senator Thompson.
Madam Chair, I move we pass out Senate Bill 204 favorably.
Is there a second? I'm sorry. Yes, Senator Pyle.
Second it if he amends his motion to put it on the consent calendar.
Oh, I will amend my motion and put that on the consent calendar and pass it out favorably.
And we have a second. Committee, with this bill, Senate Bill 204, we did hear from the reviser that it passed through the Senate unanimously when it was heard last session. So if that's the will of the committee, then we will vote on the motion then to pass out Senate Bill 204 favorably and put it on the consent calendar. All those in favor, aye. All those opposed, nay. The motion carries. Thank you, committee. And then we will next turn to Senate Bill 8. Senate Bill 8, if you'll recall, we worked several weeks ago, and I wanted to know the the committee's thoughts and the will of the committee, and so we'll work Senate Bill 8 regarding increasing good time and program credits for certain offenders. If you'll recall, that bill came to us from the Kansas Judicial Council, and if we could have a short bill brief from the reviser, Mr. Thompson, regarding Senate Bill 8, that would be helpful.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 8 came to you from, just to correct the Judicial Council, came to you from the Kansas Sentencing Commission. It was at the request of the Joint Committee on Corrections and Juvenile Justice Oversight, and I believe it's also backed by the, by the Sentencing Commission. I'll just stop there. It does increase good time and program credits for certain offenders in the custody of the Secretary of Corrections. The current law is that you receive either 15% or 20% good time credit, depending on the type of crime you committed. The bill amends that so that you receive 25% for a person if you're in prison for a person felony, and you would receive 40% if you're in prison for a non-person felony. There's also an adjustment of program credits. You can currently earn up to 120 days of program credits, and the bill would add 30 days to that. So you could receive up to 150 days of program credits.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Seeing none, then, is there any discussion on Senate Bill 8? Seeing none, is there a motion on Senate Bill 8? Senator Thompson.
Madam Chair, I move we report Senate Bill 8 out favorably for passage.
Is there a second? Senator Wilborn.
Madam Chairman, I move second the motion. Thank you.
Thank you. Committee, any discussion on the motion to pass Senate Bill 8 favorably out of committee? Seeing no discussion, then we'll vote on the motion. All those in favor, aye. All those opposed, nay. The motion carries.
Madam Chair,
Yes, Senator Pyle.
do you have a bill number for the KEMA bill you said you'd be doing next week?
No, not yet.
All right.
Not yet. Working on it. Committee, we might also be looking at working Senate Bill 57. So be thinking about the bills we have heard, and then those that we are probably going to be working on. And next week will be busy, as we know, to get bills heard and worked before turnaround. And certainly we will be looking at and I apologize for using the acronym KEMA, the Kansas Emergency Management Act. It's an acronym that's used to shorten up the title a little bit. So if you have any questions about that coming up, please contact me. I'd be happy to discuss those with you. And with that, then, I thank the committee for its work. Senator Pyle, looked like you had a question.
Well, Madam Chair, I am still working in committee last week when I mentioned to Jason Thompson. We shifted that over to Joe Walters, and that bill has not been introduced. We're still drafting. Be a great place to put it on the KEMA bill if the committee was willing. Rather, I would just bring it as an amendment, but just a heads up. But it basically is the expansion of the State Finance Council under emergency management, so that there's a representative on the Finance Council from every state school board district, which is 10 districts across the state. And I just simply put that I think she's drafting it odd years or even years. It just moves from the speaker to the president as to those appointments if we're under emergency. It's only under emergency declaration that the expansion takes place, but there were many of us in KEMA that felt like we weren't represented on the State Finance Council during this declaration. And so I'm just trying to address those concerns. And, but I will probably have to introduce that in an exempt committee based on the timetables right now, but might possibly have, when we get that worked out, bring it as an amendment to that bill. Thank you. That's why I was curious about the number for the bill.
Thank you, Senator Opile. Appreciate your thoughtfulness on that and the concern that you're bringing from the interim KEMA committee. I was not on that committee, but do understand that that was a concern that was discussed there. And the bill regarding KEMA will be introduced in another committee, not this committee, because we're beyond the time to do that. But Senator Wilborn, did you have a comment?
Thank you. You answered the question. Thank you.
Sure, but we will be working the bill here in this committee. So any other questions or comments? So seeing none, thank you, committee, for your work today and for those following online, and we are adjourned.